Thank you. Senator Padilla.
Thank you, Mr. Chairman. Good morning. I appreciate your participation today in this hearing. I have two specific questions regarding the potential liability of, quote, passive receivers, including municipal water and wastewater districts for PFAS under CERCLA. EPA's enforcement policy is to refrain from bringing actions against these municipal entities. The municipalities, however, remain vulnerable to third-party actions seeking their contribution to response costs. The municipalities can attempt to defend against such third-party actions by reaching settlements or de minimis settlements with EPA that protect them from third-party contribution actions. Rob Fox, a leading CERCLA attorney, testified in this committee at a hearing on PFAS liability last year that a Supreme Court case has ended settling passive receivers' ability to defend against third-party claims. And specifically, in the Atlantic Research case, the Supreme Court stated that third parties could bring cost recovery actions under Section 107 of CERCLA against settling passive receivers, even if they were barred against bringing contribution actions under Section 113 of the statute. I know it's getting very technical here, but this is important. The case raises significant questions about what proportion of potentially responsible parties can seek cost recovery claims and the extent to which a court, using its equitable discretion, would reduce any liability for settling passive receivers. Ms. Bowers, I understand you're still researching the issue, but can you provide some initial thoughts on how the Atlantic Research case affects passive receivers' ability to defend against third-party claims?
Thank you for the question, Senator. As you noted in the question, there are two different types of actions to recoup cleanup costs under CERCLA. There are cost recovery actions under Section 107A of the statute and contribution claims under Section 113. Which parties are able to bring claims under which is probably a little bit more technical than we can go today, although I will note that when a party is able to bring its claims as a contribution claim, which is typically when a party has itself faced liability, it is barred from bringing a Section 107A contribution cost recovery claim. It's also correct, as you note, that EPA's enforcement discretion policy, as well as CERCLA's contribution protection provision in Section 113F of the statute, provide protection from claims for contribution. The question of whether there are additional claims that passive receivers may potentially face liability for outside the universe of contribution is a difficult one to answer and would require pretty fact-intensive analysis of the nature of the settlement with EPA, the claims that are being brought against that passive receiver, as well as how a reviewing court, whether and how a reviewing court applies any equitable factors to evaluate the extent of that passive receiver's liability for response cost. I would be happy to discuss this further in response to additional questions.
Yeah, and we'll definitely take you up on that offer because, as you can imagine, there's no shortage of local governments, wastewater, and municipal water service providers that have shared this concern, not just with my office. I know my colleague, Senator Schiff, as well. Maybe this is a follow-up in the time remaining, and this is for each of the witnesses. How well do potential settlements with EPA protect municipalities and others from actions by third parties? And I guess what specific circumstances concern you if you don't believe the municipalities and other parties are sufficiently protected? We'll start with Mr. Gerstenberg.
Well, we believe that certainly based on science that you can trace back to the polluter who initiated the PFAS contamination. We believe there's cost-effective solutions to be able to support. There's funding that's been released, $2 billion under the government to be able to help wastewater treatment plants, as an example, begin to put treatment systems in. There's also funding from settlements with large companies such as 3M. There's funding that exists. And we believe that there is difficulty accessing that funding. People are not readily aware of how to get to that, to put treatment systems in to help protect human health and the environment.
All right, to be continued. Ms. Palonus?
Yes, thank you, Senator. Settlements are just one tool in the toolbox, but not a solution in and of itself. They're site by site. There's no guarantee they'll be offered. It's at EPA's choice, and they don't provide the upfront certainty or the nationwide relief that contractors need. If a contractor's talking to an EPA attorney about a settlement agreement, it means they're already in the mix as a potentially responsible party, and that's not where contractors want to be. It means lawyers' fees. It means expending company resources. Contractors would still need to buy peace. It doesn't fix the liability problem. Also, settlements with large contributors could actually make things worse for contractors, particularly if they're broad. It could make contractors and other downstream parties more exposed to full CERCLA liability and take away contractors' cost recovery rights.
Ms. Bowers?
Senator
Thank you.
Curtis.
Thank you.
Well, Mr. Chair, did Ms. Bowers want to also briefly respond to the second question?
Sure.
Thank you. The question of whether the protection that's afforded by EPA's settlement with a passive receiver, whether that's adequate, raises policy considerations that are beyond the scope of what I'm able to testify to in my capacity as a CRS attorney. What I can say is that it is difficult at this point to identify the specific fact patterns under which a party that receives contribution protection under CERCLA would still face liability under CERCLA. I would note, though, that even with protection from liability under CERCLA, parties may still potentially face liability under other federal or state laws.
Okay. Thank you very much. Thank you, Mr. Chair.